start with the definitions. Promoter, a person who constructs or causes to be constructed independent building or a building consisting of apartments. So he should be either constructing or causing to construct. So a landowner giving development rights is causing to construct, and definitely the developer is. Even the contractor who constructs could also fall into it. But of course other requirements should also be fulfilled. Other requirements are it converts existing building or part thereof into apartments. There are many times the buildings which are converted into apartments and sold. And both of these things, either construction or conversion, should be with the purpose of selling all or some of the apartments to other persons. Now, selling, the intention of selling is very important. So, if any of these activities are done with the intention of selling, then you are a promoter, otherwise you are not a promoter. And it includes these assigns. So, whoever is an assignee of the development rights or the property in the construction with an intention to further construct and sell, then that person is a promoter. Is landowner a promoter? So there is always a question, and it has implication on the maintaining that special account under 421D, because that account, I think chartered accountants are much concerned with that account. So a promoter, whether promoter is really whether landowner is a promoter or not. Yes, if he causes to be constructed for the purpose of selling the same. If I enter into a development agreement as the landowner or a property owner, maybe a redevelopment or otherwise, and if it is for the purpose of selling the area which I get, then that is definitely attracting that I am a promoter, and that 70% rule, special account, would also be applicable to me. However, if I don't intend to sell, it is only for my own use, then definitely it is not I am not a promoter. Now, what is the implication? The implication is that one, I'll have to keep 70% in the account till the project is complete. Out of that account, as a landowner, I am not going to use any of that for the purpose of development, because it's not my obligation to develop. Practically, my amount will be blocked for a very long period till the development is complete. So, whatever amount I get by selling the premises, I will not be able to practically use for my benefit for a long period. Now, here another issue is that if there is a default by the developer, what will be the liability of the landowner? However, there is a provision that landowner can very well limit his liabilities in the development agreement itself. And if we limit the liability in the development agreement, then even if your amount is there in that particular account, still that amount cannot be touched for completing the project. That is what the due is. Now, I am giving you an example of some societies. Generally, right now, 90% of the development rights are given by the society. Society gives the right that the land owners, existing members, they get kind of some area, additional area, some corpus, rent, whatever. The benefits are generally given to the flat owners, the existing members. Now, in that case, if at all there is some default by the developer, society is not considered as the responsible person. Okay, we'll see later what are the effects of termination. After termination, what are the effects? And that effect shows that the landowners, societies are insulated in case of default by the developers. But still, the RERA maintains that in case of landowner selling to premises, that 70% should be kept aside. I don't know to what extent how it will be used. Maybe those who are buying from the landowner, those who are purchasing from the landowner, they may get some benefit out of that particular fund. Allotee. The definition of allotee is a person to whom a plot, apartment or building has been allotted, sold or otherwise transferred by the promoter. Includes the person who subsequently acquired the said allotment through sale, transfer or otherwise. So even resale purchase is also included in the definition of allotee, but does not include a person to whom such plot, apartment or building as the case may be is given on rent. Now if you see this given on rent, there is a contradiction. Earlier they have said that if you see sold, whether as freehold or leasehold, what is the meaning of selling on leasehold basis? Practically, tenancy is nothing but a lease. Technically, it is a lease within the meaning of Transfer Property Act. So, tenancy is nothing but a lease. So, if something given on rent is excluded, the person who is having any premises on rent is excluded from being allotee, then this leasehold, how could we have a coordination between these two things? Maybe we can have a coordination that a landowner is an difference between leasehold land sale and given on rent. The difference is it could be said that long lease of the land with the right to redevelop and own on ownership basis the flats, then in that case one may be an allotee. Something similar to what we have in Mattunga. Mattunga, most of the buildings are estate. So you have the leasehold rights in the land and ownership of the flats. Actually, it's very difficult to accept that you are owner of the flat with the leasehold rights in the land. But it's a fact that it is widespread that though you are having leasehold rights in land, you are owner of your flat above. Another allotee, whether a landowner or an existing tenant is covered in this definition. If I get covered in this definition, then even landowner or tenant can also approach RERA in case of default by the developer. At present, the view is in general that the tenants or the landowners are not covered in the definition of allotee and they cannot get the protection under RERA. However, if technically we see, I think it is. I think landowner and tenant also should be covered under RERA. If they do fulfill the definition requirement of the definition is very much fulfilled. So I just see a person to whom plot, apartment or building has been allotted, sold or otherwise transferred. Definitely it is allotted. In case of development rights, the landlord is given. In case of PAAA, the tenant is allotted. They are allotted some particular plot or a building or a apartment, and it includes, that is of course not relevant, but does not include a person to whom such plot, apartment, building as the case may be given out to rent. So definitely the PAAA or the development agreements landlords and the tenants are not given on rent. They are in fact allotted on ownership basis. So, according to me, there is a chance to argue that even tenants who are getting in PAAA should get the benefit under RERA. In fact, they have paid their entire consideration forthwith in advance. They are right, they have already given away, their possession. So, in fact, their consideration is already paid. However, definitely till now, this particular thing is not accepted. I think may not be argued, but one can try. And of course, it will not be successful at the RERA level, not even at appellate level. Maybe at High Court or Supreme Court, one can try. But to that extent, one should be ready to fight. Now, again coming to another definition, apartment. Apartment, by what name called, means a separate and self-contained part of any movable property. Here, a very important thing is self-contained. It should be self-contained, then only it is an apartment, otherwise not. So, this is many a time, many of the shops or offices are not self-contained. So, whether there is an appointment within the meaning of this, practically it is being considered, and that is where this particular act is being implemented. But this act has many instances where strict legal interpretation is not followed. We see otherwise also. Even for allottees, it is not followed. Here also apartment. Though it is not self-contained, still people are considering this as a part of RERA, and even RERA is also accepting them as the allottees of an apartment, including one or more rooms or enclosed spaces, used or intended to be used for any residential or commercial use. It should be intended to be used for residential or commercial use, such as residence, office, shop, showroom or godown, or for carrying on any business, occupation, profession or trade, or for any other type of use ancillary to for the purpose of specified. Now in that case, there are few instances which may not fall within this. Non-commercial social use, CBOCA or ICAI, purchasing some premises from a developer in some particular premise, or trust, buying say social activity, charitable trust, buying some premises. Now whether for that non-commercial purpose, if it is purchased, non-residential purpose, it is purchased, and in fact it is passed as a multi-purpose room or multi-purpose hall, or maybe as a religious structure, some religious trust is buying, whether it fulfills this particular requirement for an apartment, whether that is an apartment. So that will be a question. And even garage for parking of vehicles. Now, garage is generally not sold independently. It is always connected with an apartment. And of course, it is ancillary for residence or office. If it is ancillary to a residence or office, then it should be an apartment. If you have just a self-contained one bathroom in garage, and of course today, at least in Bombay, garages are not approved unless you use the FSI. So earlier the free of FSI garages were allowed. Now free of FSI garages are not there. So even the garages can be separate apartment if these conditions are fulfilled. It will all the question will arise whenever there is some such kind of situation. Now another definition, common area. So common area includes land, staircases, lifts, fire escapes, clubhouses, basements, and installments for central services. Okay. everything comes up, is covered in this except your own apartment. Who owns the common area? Definitely it would be with the society or the owners association, land owners association. If we look at the recent past, Bombay Dyeing in case of Spring Mill case, they tried to uh, retain the ownership of all the garden and other common area. However, the association, the society went up to the Supreme Court and they got the orders in their favor. So those things were being tried by utilizing the model of condominium under the Apartment Ownership Act, and that was actually defeated. And there are many other old developments where the apartments are made by the developers or the landowners, and they are keeping to themselves certain rights in the common area and other things because of the declaration which is filed in under Apartment Ownership Act, where there was no authority to control it, and such kind of things are still found in the olden developments. Covered parking slot, it is also a parking area. It is a common area. It is also a common area, and of course that also is owned by the society or association and cannot be sold. But and if we see the provisions of Act and the rules very minutely, literally the parking spaces were not meant for sale, and the wordings are such, even exclusive user rights could not have been given. But by RERA Circular 36 and then the RERA Order 54, in fact, though apparently it looks that it restricts the developer's right, or it puts certain restrictions on developer, or it tries to regulate that minimum size and that. But in a way, it was to give a way to sale of parking areas, and in fact, developers are constructing podiums, they are constructing basements. If you don't allow them to sell that particular area, then it was misnomer. It was not actually properly drafted. So there has to be some kind of limited common area concept in RERA also, which is not there, which was there in MOFA. In MOFA we had limited common area. Right now we don't have that, but practically by these circulars and they have just tried to bridge the gap. Okay. If you see in MOFA, there was a Supreme Court judgment in 2010, Nahalchand, Laluchand Private Limited, and there was another judgment also later, where it was very candidly expressly provided that stilt area parking spaces are not flats and garages, and under MOFA only flats and garages could be sold, nothing else. Today also in RERA, even apartments are only sold, nothing else. However, exclusive user rights are given pursuant to those circulars and orders. Parking slots, it cannot be sold separately. They are part of common areas belonging to society, and street areas were not even allowed to be given. However, still in practice, everyone was allotting and everyone was following. So under RERA, garage is separately defined as a space with a roof enclosed by wall on three sides meant for parking of vehicles, which can be sold along with an apartment. So here they have put a restriction that it can be sold along with an apartment and not separately. Open to sky areas are generally common areas and legally cannot be sold. Open to sky margin areas, the compound areas, they cannot be allotted also or sold also. Society can allot in accordance with Maharashtra Cooperative Society's rules, bylaws. that can be allotted, and that too on yearly basis. Every year there has to be a new allotment as per the rules. Though the society may not be doing a different thing, but as per rules, one has to, every society has to allot freshly every year. So, garage के बाद ये जो open area, open to sky area, that cannot be sold, that cannot be even allotted, or exclusive user right cannot be given by the developer. And of course, that circulars are, first circular was exclusive user right for covered parking was recognized. There they had given certain restrictions, but the developers were misusing it, not properly interpreting it. Most of the developers are only writing number of parking slots in the agreement and not exactly the parking slot number. They are not giving that in the agreement. Later on, they give the allotment letters. However, both these circular and order are expressly saying that you should be giving specific area or number, but nobody is following. And even in the second one, they have actually stated very expressly that type, location, number and dimensions must be provided in the agreement or allotment letter, whatever you are giving. But most of the developers, 99%, they don't. And later on, in fact, in this circular itself, and order itself, it is mentioned, the problems are occurring that first they don't give the specific number, dimension and other things, and later on the developers allot such kind of parking spaces to the allottees, purchasers, then you can't even open a door. It's difficult to open a door also and get out, or ingress, egress, that all this is very difficult. So basically all these things are already provided, but nobody is following. And let's wait for some orders if somebody goes to the court and gets it. And in fact, in case of, we'll see later also, parking space must be approved as such by NCGM. What today happens is, say parking is approved by NCGM, in a particular hall, if say 8 parkings are approved, developer will make 10 or 11 out of it and allot it. This is a very routine, regular thing which is being done. And people consider this as everything is fine. But no, even under this particular circular and order, they have to allot only such parking spaces which are approved and not the one which you are carving out. One which you are carving out cannot be sold or cannot be allotted. You people, if you are having any questions, and in fact I would like to have discussions, if you are having any questions, definitely you people would be either facing or your clients would be facing certain issues. So real-time issues, real-time questions would definitely make this lively. So I really invite you people to come up with the participation and question. Sellable and non-sellable portions in the property. Apartment, carpet area and common areas are the relevant provisions. Carpet area, net usable floor area of an apartment including area covered by internal partition walls. And what is excluded is given service shaft where balcony is open terrace area. So actually an apartment which is comprising of carpet area can only be sold. Now this balconies also cannot be sold. However, in Bombay, the balconies are permitted only with using FSI. Still, it cannot be sold. And balconies and open terrace areas, only exclusive user rights can be allotted if they are approved as such balconies. If those areas are just open to sky leftover area, because in many of the buildings on the top floor, there are certain areas left which are compulsorily left because you don't have the enough FSI to cover it up. so they are left open. Actually, that is not a pocket terrace. Many times even on the first floor such kind of areas are left. So these are not the pocket terrace, and most of the developers do sell the rights for that, and they would definitely not write that in the agreement, but they'll say it is yours only, you only use. Officially, the entrance would be from the common area, from the lobby area in the building, and then after the OC or maybe before also, they'll close that particular entrance and give you the entrance from your home inside. Okay, now here also, whether exclusive user rights for such kind of common areas can be granted, it's a grey area. I can argue for both the sides. I can argue for both the sides, and that with full vigor and force, that yes, it cannot be exclusive user area, cannot be given, and I will say that it can be given. If parking area, exclusive user rights can be given, why not such kind of open to sky areas in the building, which is no way affected, no way is concerned, no other authority would be concerned about it, and if somebody is given exclusive user rights, what's the problem? So, there are so many contradictions. If you have such kind of open spaces, open to sky areas, consensus is you cannot allot. Parking area, consensus is you can allot. But both are having equal legal basis. Both are common areas, both are constructed by developer. It's only that mindset is that that particular area cannot be allotted, this area can be allotted. It's just a mindset.
As per plan, that is a common area. As per plan, what has to be?
As per plan is the common area, even parking area. As per plan is the parking area, common area. It is not an apartment. See, as per plan, that is also a common area. In fact, it's in the definition of common area. Podiums still are part of common area.
But when I say parking, while deriving number of parking, plan generally is derived on the basis of how many units are there, what is the configuration there. And obviously, whatever is the regulation which is followed. So, in a way, we can attach that particular parking with some unit. But when we talk same about other common areas, how that will be considered as being.
When you are connecting parking, it's a very good argument in favor of parking. But I would say just because parking is arrived at on the basis of the number of apartments, having regard to the regulations, many a times one out of four, one against four, one against one, two against one, depending upon the area of this. But at the end of the day, it is a common area. It is a common area. If one common area exclusive rights can be given, why not another type of common area? Just because parking is arrived at in a particular way, doesn't mean that you grant. Yeah, RERA is given the circular. RERA is given circular, so it's allowed. And in fact, in the similar set of law, MOFA also has a very similar law. If we keep that order and circular aside, RERA is having a similar law as MOFA, so far as common area is concerned. In fact, there is no concept of limited common area which MOFA had. Still, the Supreme Court had held that parking in the street area, parking area cannot be excluded. So there is a Supreme Court judgment in similar kind of set. It's just that the political will was that this could be allowed, and by circular it was allowed.
What about close parking? Sort of a garage.
Which garage?
groups whenever this thing is there, garage sort of a thing.
See,
That is allowed.
in Maharashtra,
SI use, na?
in Maharashtra, garages are always with FSI used, and garages are permitted to be sold along with an apartment. There is a special provision.
So you can open an office there in that
No,
garage.
it is for parking. Garages are meant for parking. You cannot open office over there. It will be a change of user and in breach of MRT, Maharashtra Regional Town Planning Act. In fact, one of our temples was erased because it was a temple in
After society is formed, then that garage will be under this society. This thing, society can sell it or rent it for office purpose.
just because nobody is opposing it in the society, and society rent it or sell it for purpose other than parking, it is in the breach of MRT. It is in the breach of section 44 MRT. It is in breach, no doubt about it. See, practically many things happen. Nobody bothers. But it is a change of user which is unauthorized and not allowed, permitted in the MRT. In fact, IODs where the garages are allowed free of FSI, such kind of areas, that open to sky areas. In that case, the IODs, there is a special provision that you are giving undertaking to the municipal commissioner that you will not be using the area for the purpose other than it is approved. There is an undertaking in the IOD. If you see the IOD, nobody reads. I also don't. For some matter, I had to. So I read it. So उसमें कहीं पर फ्राइड में लिखा हुआ है. So there are, see, these are all aberrations that चलता है. In fact, very old users of garages are non-parking use of garages. If the BMC is, has decided that they want to stop that, they will stop. अगर जो developer has already set with the BMC, they'll do it. Otherwise, nobody bothers. Very old usages are also being questioned. In fact, garages are demolished. In such cases, garages are demolished. I don't know why it is demolished. There is an unauthorized use. If the unauthorized use is stopped, why demolition? Because garage anyways is a legal structure. But no, they demolish only. Because they have the reason to demolish in the backside. Somebody is, pushing to back demolish. So I've already dealt with open to sky area adjacent to flat, and of course the saleable is now nothing but a carpet. The carpet will include even the internal walls, but that concept of super built up area is faded. Still, I was surprised to see that concept in Nashik, and surprised to see that in some of the tier 2, tier 3 cities, but in Bombay it is faded.
Some of the areas, like you said in the previous slide, sky, many of the flat owners who has got an adjoining open terraces are in past been sold also, and now it has undergone for a redevelopment. Whether the buyer will have the protection right in that, or it will be waived off.
They don't have protection. Even if you have bought it
Correct.
by a registered document,
Yeah.
no agreement can override the law. It cannot override an
I'm
agreement.
talking about when the MOFA was there.
MOFA, it is overriding, it is actually in breach of MRTP,
Okay.
Maharashtra Regional Town Planning Act. You cannot have ownership. In the past, it was very much possible to have exclusive user because there was a specific concept of limited common area. Limited common area का जो concept था, in that such kind of communal areas were given on exclusive user right basis.
But if that is mentioned in that agreement, like what you said, exclusive right given to a particular person, then he will be protected by
He will be protected so far as user is concerned, but he cannot get any area in case of redevelopment.
compensation.
You cannot get compensation for that.
Okay. And same case with the even garages also.
Garages, they are getting what do you say, parking area in the street or in poli. So garages are not getting any enclosed area against, so far as law is concerned. The developer may agree, that's a different thing. See, many a time, many things are agreed, though it is not obliged. Though I am not obliged, I may agree. Maybe that may be, for me it is a small thing and I don't want to waste my time or the project. I don't want to delay the project. There could be reasons. But definitely you don't have a right. Yeah. In case of Mahara redevelopment in Bombay, the proper Bombay Mahara redevelopment, if there are old garages before 1962 or 63, which have been used since then for commercial purposes, there is some 64, some date. Before that, if you are, since then you are using, then that user is legalized by circular, PMC circular. And Mahara itself considers, this is I am talking about BMC, and Mahara is considering before 95 if you are using, then they are granting FSI against that. However, BMC has stopped giving the approvals. Earlier, whatever FSI Mahara was granting, BMC was accepting and going ahead with passing of the plans. But now, since last maybe 1 year or so, these things have cropped up. That even though Mahara is approving, BMC is behind. And recently, in one judgment, the High Court itself has appointed or cautioned BMC that you must check what is approved by Mahara, and it will be your responsibility. Just because Mahara is approved doesn't mean that you are absolved. So now I don't know what will happen for such kind of, that in 1980s somebody started using as a commercial, some garage, say before 95. Okay, and today there is a redevelopment. So some of the developers are offering कि इसके सामने हम आपको दे देंगे. But in my own office, we had to file a writ petition, but we had not succeeded. So it's a grey area. It is not the law is not yet finalized, but very much likely that such kind of leniency won't be permitted. Recently, what you have seen is the courts are becoming very stringent on unauthorized use, unauthorized structures. They are becoming stringent. In fact, I'll name the judges, Justice Kamal Kata and Gadkari. Their bench is horrible so far as for the tenants or occupants. उसके बाद मैटर गया तो खत्म हो गया. Nobody is expecting that they will get any relief because they are very strict. They are very strict about unauthorized use.
And what about clubhouse? So you said that clubhouse is given.
See, clubhouse is generally free of FSI area, and of course it will not be private ownership. It will be of the society only. In case of redevelopment, you will get the clubhouse, means the society will get the clubhouse as per current provisions of the DC regulations. So you get the clubhouse,
But
but
in that case, FSI will not.
no, clubhouse is never with the FSI. It is without FSI, free of FSI. Nobody would use FSI in clubhouse because it is permitted without FSI. And clubhouse cannot be sold, its rights cannot be retained by the developer. There are many big developers who are retaining the rights to the clubhouses. We come across such kind of agreements. But there would be some day where such kind of thing would be adjudicated. It's a common area, free of FSI area. How a developer can retain rights? No. Very clear that all common area has to be transferred to society.
Yeah, you mentioned that the tenants are not covered, the tenancy rights which are there in the pagdi kind of a buildings which are not covered under the RERA, even though they have paid the entire consideration by way of giving away their tenancy rights. What common practice is being used to protect them? Is Contract Act sufficient? But is there any other tribunal that's handling these kind of?
No, actually the Eknath Shinde has already made an announcement maybe a year back or 6 months back that some specific special law they are coming up with for such kind of tenants, public building or society redevelopment to protect them against the defaulting developers. But they have not come up with such kind of thing yet. Maybe that was some election gimmick, I don't know what was. But they have made it, maybe अभी आज नहीं तो एक आध साल में 2 साल में हो जाएगा. So we'll get some special law for that.
But in common practice, are they doing something? Because I heard somebody saying that you can purchase additional square feet area from them at the time of the agreement and then you become their buyer. Then in that case, you would be.
There is also a kind of gray area in it.
Okay.
See, I would, but you have given a kind of solution.
Yeah.
I would also give, but it is with a caution.
Okay.
See, it's a gray area. Apartment is not sold. Only part of that area is given, larger part area given for consideration.
Yeah.
As an addition to your
Correct.
people. So I don't know what the RERA would take you, what High Court would take you later. All that would depend upon how it is argued and what is the driving force for the member to give the judgment. There are many driving forces.
Will that time only Contract Act will be applicable?
Contract Act, Transfer of Property Act,
Like, but for
Maharashtra Rent Control Act, all this would play a role.
if suppose redevelopment is there, then public building will automatically become owners.
That will become ownership after it is redeveloped.
Huh?
That will become ownership after it is redeveloped. And in any case, even if it is becoming ownership, it has no connection with RERA. Even today, some society is getting into redevelopment. The society and its members are not getting any benefit under RERA.
So in center.
Fortunately, there are few judges in the High Court who have taken very positive view for the tenants, and societies. And good judgments are coming in. If the developer is defaulting, keeping all things aside, once the developer is kicked out, the society is allowed to redevelop, appoint new developer, many things are allowed.
And then what about redevelopment? Then there are not apply.
In case of self-redevelopment, whoever are purchasing that the self-redevelopment, for them the RERA would be applicable because then society would itself become the promoter. But if the self-development is not for selling, only the existing owners, the flat owners or the members of the society are getting bigger houses. They don't want to sell outside. They chip in all the costs.
What about
Then there is no RERA.
Then what about relationship of developer and society? Then in that case, RERA will not apply.
I didn't get you.
Yeah. If suppose developer is different, society is only developing, then in that case, RERA will not be
So
applicable.
developer is
Different.
different. The developer is different. Society is not a developer. No. Society has only given the development rights. Okay. And in that case, we will come later. There is a slide in it. We have provided that. I'll just take it right away. That in case of defaults by the developer, if the society is terminating the development rights, allottees of the developers are not getting any protection against the society. Their rights is only to recover their money from developer with interest. There are judgments of High Court by Dedhia and others. There are 3 judgments which are quoted. So, see, this is very harsh. Nobody would like to hear this, but it's a fact and a very good judgment from the point of view of law. It's a very good judgment because actually the developers had mischieved that the allotments are done, forged allotments and low price allotments. These things are happening, and then they'll only claim the rights, which the third party rights is already created. But the courts have said that whatever third party rights are created, those are all through or under the developer. So if the upper level development rights is favored, all the rights below are gone. You only have a right to recover from the developer.
We say that whenever there is a redevelopment, we are purchasing planning development. Why to do with society also as a confirming party in the purchase agreement?
Definitely, but nobody knows. In fact, when I am for the landowner, I specifically mention that my obligation is only to give conveyance, nothing else.
But while registering RERA, they are taking declaration and affidavit from landowner or society also that they will be completing the project, they will follow whatever affidavit builder is giving, same affidavit is provided by the landowner or
Now those procedural things, whatever they are insisting, I'm not sure because I'm not into procedural practice. But if at all they are insisting, they are beyond the law. In fact, see, Vedic judgment and other judgments, there are 3 judgments recently in last 5-7 years. But RERA till now recently they were favoring the allottees, but at the end they had to. They also now stopped taking the side of allottees.
when we see promoted definition, it's the person who is developing or causing to construct.
For the purpose of sale. Society is not causing to construct for the purpose of sale.
When you enter into the redevelopment agreement, there the intentions are written on that the additional area will be generated, which is sold, everything is written.
And society has given the authority also.
Society is not giving the authority, it is granting the rights. So sale is not on behalf of the society.
It is not on the
In fact, for the society wherever I am, for the landlord wherever I am, I expressly make a point that I will not be giving any power in power attorney to sell. You don't need my power to sell. So there is a difference selling in my name and on my behalf and selling independently because we are having contractual right.
Now, just because we are having this discussion, so suppose developer is not being able to develop the things, and that's why, as you said, that allottees will be lower because society will not take stand for any of the other. Now, suppose allottees are taking developer to the insolvency, then also society's rights will be with the society or it will be directly in the IBC.
If there is an IBC mein gaya, definitely there would be a breach of agreement by the developer. If there is a breach of agreement, the agreement will not sustain. IBC will be taken up later. There is a slide on IBC also. But see, every situation there would be some, as per the situation you have to take. Now, today, if we see that, okay, developer has defaulted in the agreement. So, developer is not the owner of the land. It is just having executory rights. So IBC cannot protect, NCLT cannot protect the developer or his creditors or the flat purchasers who are below the developer if the executory contract is not fulfilled. Executory contract cannot be continued. You cannot ask the society, by executory contract, even if they don't fulfill the promise. Had it been that the landowner many times makes a mistake that they give the conveyance to the developer, and in turn they get right to receive the flat back. Now in that case they are gone. In case of IBC, they are gone because they have lost the ownership. Here in this development rights, I retain my ownership. I am retaining my ownership. So if ownership is with me, you just have an executory contract. You execute. I give you the right to execute, but if you can't execute, get away.
But it may possible that their compensation for consideration may involve some area to the developer.
I didn't get it.
The redevelopment is done. The consideration for builder is that additional area which he is going to sell.
Who is going to sell?
Developer.
Developer is going to sell. So I am not causing, as a society, I am not causing any redevelopment or construction for sale. He may sell. I am not causing for sale.
But transfer will be there from society to the something suppose.
I am agreeing to transfer. I am granting the development right, which is executory contract. But that doesn't mean that society becomes a promoter. Society is not a promoter in the sense that it has obligations of the developer. The High Court judgments are very clear. In fact, by their judgment, they have dealt with all these issues.
So that was pre-RERA.
No. I like to check. But even if pre-RERA or post-RERA, the law is same. On this part. See, on this part, the law is same. What difference does it make? At the end of the day, it's a development right. You have to see what is the nature of development right, what are the rights which are transferred from owner to the developer, and what are the rights of the allottees. So that entire thing has not changed with RERA coming in.
Sir, one more thing. In Matunda, most of the lands are for 999 years lease or life. While those going for redevelopment, BMC is converting only 30 years. Whether it is legally allowed?
See, basically, you are a lessee.
Yeah.
When you took the lease, you had very limited right to construct. Now, if you want to get further right to construct, redevelop, lessee is imposing another condition. Otherwise, you keep it the way it is. You continue with your 999 years.
They are compulsory converting into
But
redevelopment.
because you want to redevelop, don't redevelop.
But not allowing. They compulsory makes.
But if you don't redevelop, they are not converting into 999 to 99.
No, that is okay, but
They are making forcing. Otherwise, they apply the law.
if suppose
73A.
it is in a diabetic situation, they are forcing it.
If it is a development situation, you are the owner, you repair it, you reconstruct it. There are provisions that you can reconstruct same area. Who says that you want to redevelop? See, if you go for reconstruction, they are not entitled to reduce or use speed.
If you ask for an FSI, I think then only in case of
1.3. I think 1.33 would be in most of the buildings here. Whatever. But whatever it is, today when you want an additional development right, you are just a lessee. You are not the owner. So under the lease deed, whatever you had right, you already have. Now you want to exceed, so you have to get the permission from the lessor. So lessor is saying that I give you the permission only on so and so conditions. I think some litigation has already done. I don't know what the outcome is.
So many people have filed their writ petition in the High Court, but yet no decision has come.
No decision has come, but see, I am just arguing this way.
Yes, yes, right.
There could be another argument on that way also. I have not gone into depth into that because nobody is interested. As a lawyer or an advocate, I will not be going into depth of a matter unless somebody is interested. Why to waste time? But prima facie, you are entitled to construct certain things under the lease. You have already constructed. Now you want to further construct, further reconstruct, redevelop. You come up, if you are coming to me, then I am imposing another condition.
Is there any harm in that lesser period, smaller period?
Definitely, after 30 years, whatever other conditions they would bring in, you have to accept it. Of course, 99 years lease, if it is reduced to 30, after 30 you are nowhere. You are at the mercy of BMC. It's a different thing that so many buildings are there. There would be something, some policy where there would be some renewal or extension. But of course, there is a very big loss to the right.
Very big.
Now coming to registration with RERA. Registration compulsory. Registration compulsory only if you want to advertise, market, book, sell, offer for sale or invite to purchase. If you don't want to sell before the OC is obtained, you don't need registration. You just construct it, obtain OC and then sell. No RERA registration needed. If the area is not exceeding 500 square meters,
During construction, we cannot sell.
if registration is not there, you cannot sell. If it is not registered, you cannot sell. But today, even if the area of land is less than 500 square meters, then also it is not compulsory registrable. However, most of the developers, even for 300, 400 meters, they do register under RERA because registration under RERA has now become a necessity to sell. Nobody is interested in buying if you are not registered with RERA. The purchasers, the landowner, flat purchasers are insisting that whether it is RERA registered, then only we buy. And there are reasons behind it. If the number of apartments are less than 8, then also it is not needed. So, if you want to register, either of these should be compliant. Means if it is you want to sell, then you will register, provided that if it is less than 500 meters and less than 8 apartments, you may not register. Instead, you can sell. This is what the law is. However, there is, RERA is also having such, bad practice that once the registration is not there, they don't take up the complaints under section 18. They don't take up complaints under section 51, 71, 72. They don't take up. But I think it's a bad interpretation of law. Just because registration is not compulsory for a particular project doesn't mean that RERA is not applicable. RERA as a substantive law is definitely applicable to all the developments for the purpose of sale. RERA is applicable. But earlier the MOFA was there. With the MOFA, all sections are removed. All are deleted. Only the sections relating to leave conveyance are sustained. What about those who are not, the projects which are not registered? It's a different thing that market itself is now forcing them to register. And they are registered. But if it is not registered, then what? They don't have any protection, not even MOFA. This is not actually intention. कि भाई छोटा प्रोजेक्ट को कोई प्रोटेक्शन नहीं. So according to me, even if we go through the provisions of RERA, it's very clear. Only registration is not necessary, but that doesn't mean that you don't have remedy under the RERA. Remedy is connected with registration officially today, but that's a very bad interpretation of law and bad implementation of law.
So nowadays there are some pre-launch events and all which the builders are doing, and they take a token amount of intent. So
That is definitely in breach of it. If they don't have the RERA registration, they cannot take a single month penny. And if the investors are cooking such kind of things, then they don't get the protection under RERA.
Then at what time they are taking registration of RERA?
They can take registration of RERA once they have the ID. For registration, they minimum need to have ID. You have to file all the needs of registration. One need is that you need to have a plan class. Plan should be approved.
But here what a bit of time. Builders are not registered in the RERA. People are taking in other than the booking. Money,
Now-
everything. But
See-
subsequently, as a loan, they are showing as a loan. Subsequently, they repay the loan and take fresh purchase.
Who will complain about it?
Huh?
Who will complain about it?
People
But,
are paying.
but who will complain about it? Say,
Like,
the
nobody-
court or authority will take cognizance when there is someone who is complaining. In fact, developer, allottee, investor, everyone is standing law. They want to do something in breach of law. Then who's going to go to RERA? To forget it, it's there maybe. There is no one to complain, no?
Nobody.
Nobody is concerned.
Second and third condition you said about in 500 square meters, whether the 8 apartments will be possible or if it is
Area of
within-
the floor.
If the area is less than 500 square meters or there are less than 8 apartments,
so if it is exceeding, that means 500 and
either of these is, if you are exceeding
that-
501,
Ah,
if it is 501, then even if you have 2 apartments, you have to register.
so do you think that 8 will fit in the less than 500?
Why not? I can have one single apartment for 15,000 square feet. In Ghatkova, there is one building, Bristol. There, the apartments are minimum apartment size is 4,000 or 3,500. And one of the apartment is 15,000 square feet. How many floors I don't know. Maybe 2 floors. The apartment, there could be single apartment. Until here. Single apartment. How many floors? How many square feet? Well, sale to investors I have already discussed. Agreement for sale now coming up with certain technical things. Section 13(2), it's a base section. Rule 10, read with annexure A to the main rules. The model form is prescribed. There is a prescription that the model form is this. And order 38 of 2022 has made certain things compulsory, that these are the things which must be there in the agreement, because actually in the model form it is very clearly mentioned, or in the act also, that the model form is not compulsory to be used verbatim. You can make changes according to circumstances, provided you provide for all the details required under the law or in the rules. However, certain misuse of that thing was being taken. So there are certain provisions which are expressly made compulsory verbatim. certain clauses of model form are compulsory. I would say that to an extent, yes, it's a statutory document, more of a statutory document than just a contract. Because many a times, in fact, even under MOFA, there are judgments which are given on the basis of model form prescribed in MOFA, though that was not part of the agreement signed by the parties. The courts do look at the model forms just because the developers have not adopted certain part of it. Courts do take cognizance of that and still implement the provisions of model form.
The practical problem which comes in model form generally is a model form gives the percentage that developer can ask from authorities slab wise. Okay. Right, think what he can demand, at slab what he can demand, then at completion, so on and so forth. They have prescribed, I think, 7 to 8 layers. Okay. Now, if suppose that is not followed, because generally what builder or developer has an argument is, if customer is ready to pay me XYZ percentage in advance, then I will be giving him discount obviously, and I am getting good chunk of amount. And obviously that the slab of payment is not being followed what is prescribed in model. Whether that is dangerous or not. Because that is prescribed in the model form.
See, basically, as I said, model form is not compulsorily to be followed. It can be amended, expressly mentioned in the rules itself. In the rules itself, it is mentioned. But that opening of that window was misused. So certain provisions are provided. Now, when you say that there has to be slab wise, you cannot have single payment, lump sum payment. Now, that is actually limiting the commercial decision. So, I don't think the law intended to limit the commercial decision. Anyone who is buying is an adult, selling is an adult. So, they should know that what they are agreeing to. Law cannot be so stringent that how to contract, at what price to sell, what to make payment, when to make payment. All this is, if law starts prescribing, and I don't think there would be any business left. Today also, I think it is very well balanced to an extent, and there would be some aberrations everywhere. You cannot have 100% perfect anywhere. Important contents of agreement for sale. As I said, that model form can be amended provided the details required under the act or the rules are provided. So which are the details I have already enumerated. I think I should not be wasting my time in reciting all these things. These are all, we have already discussed that it can, promoter can modify, it's part of Rule 10. Coming to order number 38, 2022, as I said, there were certain things which were made expressly compulsory, that verbatim that particular clause should be there. So force majeure clause, you cannot expand force majeure, that is what they have said in that circular, with an order. Formation of society, the provisions for that cannot be modified, it has to be verbatim. Execution of conveyance, that also should be verbatim. Defect liability period, yes, that also should be same. You cannot change the defect liability period from 5 years to something else. All these are actually backed by some provisions of law, act. You cannot change the act. The law cannot be changed by a contract.
What is defect liability period?
If there is anything, say leakage or some other manufacturing, construction defect or structural defect,
So minimum period is fiscal.
Yeah, 5 years. 5 years, if within 5 years there is anything, and if you claim within 5 years, then definitely it is liability of the developer to make it good. But you should be having that wherewithal to fight and go to RERA.
Then society will go.
Why society? Even individual can. If there is a leakage in your flat, which society is going to bother? They say if you want to go, you go. Practically it happens. Nobody is interested if only single person is affected. Even though that leakage is affecting entire building actually. But people don't have that foresight. Even variation in final capital area, it should be verbatim, like it cannot be more than 3%, and if there is variation in that 3%, then also there should be compensation in monetary terms. After construction, there could be a variance. And promoter's right to terminate AFS, there also, the provisions in the agreement should not be made more stringent. And promoters need to have that provisions only. I could not find the backing provisions for last two, how they are making it compulsory, but still it is a part of that order. And they have made it compulsory. Copies of IOD, CC, etc. that has to be approved. The approved plan has to be attached to agreement for sale. They have to mention the FSI details, explicit disclosure of FSI or any proposed FSI to be utilized and to be made. There is a grey area. Many times what I have seen is that the developers do write कि अभी समझो आज की तारीख में 4 FSI is permitted. They write we'll use up to 6 FSI. Today it is not available. As per the today's provisions of this regulation, is not available. But they write. I don't know whether they will be able to use that window or not.
During construction time.
If it increases, during construction time, if it increases, they say that we have made a disclosure of 6. We are expecting this. But whether that would be permitted, not permitted, I don't know. Unequivocal payment obligations, of course, 10% से ज़्यादा नहीं लेना है, but nobody follows. And payments to be linked to development, construction stages. Okay, so it will be linked. I'd say 90% on signing, 10% on possession. It is linked with the completion. So, see, that could be title report. It has to be very clear title report from an advocate, disclosing all encumbrances, litigation, tenancy rights. Earlier, subject to reports were very common. Now it's not that easy to issue. Of course, still it's an art. Date of possession, section 13(2), it must be specified date, specific date. Most of the allotment letters don't provide provisional allotment करके सब चलाते हैं. And even in few of the agreements I don't see any possession date. Now this is something ridiculous. Many times they make it dependent on some event or some ambiguity. And most of the time the RERA and the other tribunals have struck down that particular thing. That you cannot, in fact, later on we'll see that there is a judgment by Supreme Court. I don't think I put it here. There is a judgment by Supreme Court that if no agreement, no particular specific date is provided in the agreement, then a reasonable period should be decided by the court by which the developer should be deemed to have agreed to give possession. So that was in, I don't remember the name of the case, but it is a Supreme Court judgment, and in one judgment they had mentioned 3 years. 3 years is a reasonable time within which he has to give, and some other case 7 years had already passed. So court said that 7 years is more than enough. So now, if till the end of 7 years, if you have not given the possession, then definitely you are in breach of RERA, and you have not given the possession as agreed. The court has said you have not given the possession as agreed, you are in breach of the agreement itself. There is an implied agreement to give within certain time, in reasonable time. That is what the court has held. One-sided clause is generally struck down. Now, there are few clauses which are very one-sided, so they are generally struck down. Effect liability we had already discussed. Amendment to plans. Once the plans are shown to the allottee, purchaser, you enter into agreement, or some allotment letter is given, then the plans cannot be amended without the consent of the allottee. However, minor amendments are permitted without the consent. And what are the minor amendments? And there is some already exclusion given in the law, and if you see, the exclusions are not exhaustive. So minor would be minor, and it would be little of, there would be little of subjective thing. However, there is always requirement from a developer that we may need to amend the plan tomorrow, and if for that we need to go to all the allottees, it would be difficult, practically impossible. Then, well, practically I am suggesting them that whatever are practically feasible, you see, 2 या 3 या 4 options रहेंगे, you make those plans and attach it as the possible amendments. So that could be the way to tackle the situation, but you cannot get random, whatever changes you need, you will make. That permission cannot be there. Even if such kind of permission you are taking from before it, that permission is not considered as a consent for the purpose of that. Assignment of project. Of course, the consent of 2/3 allottee is required, and if 2/3 allottee consent is not there, with approval of RERA also it could be done. Early allotments and agreement for sale won't be affected in such case of assignments, and new promoter will have to fulfill all the pending obligations of the earlier promoters. If there is an assignment as such, then that would be necessary. However, in case of termination of rights, as we discussed already, so I am not taking it again, Vaidehi Akash Housing, New DN Nagar Cooperative Society, Deepak Prabhakar Thakur, Goregaon Pearl Society, all these are the laws, judgments, where the courts have, all the high court judgments, the courts have held in favor of the developer, new developer, not the allottees. Society and new developer have been absolved from fulfilling the obligations of the old developer, and allottees of the old developers are at the mercy to get the money back from the old developer when he is already bankrupt or a defaulter.
Again, in this case, can't we say that rights are created? Suppose even we say that rights are not created, that many of the customers have taken loan. So the lender has also created some rights on the property. And practically what I have seen is they have gone into the auction and they have sold also the property to some other person, banks. No doubt, banks have recovered their money, so they are free. But still the project is under construction only, because the customer is not able to pay EMI or interest whatever was due, they took the property because it was not OC property. So they auctioned the property and they had some other customer. So then how these all things work? Because ultimately the project is not complete. The landowner or society, whoever it is, they can again detach the contract. But banks are able to do it. So new customer will not have right again. So that's what they are trying to say.
According to me, the banks who have taken the mortgages from the developer or from the allottees, they are on the equal pedestal as the allottees, according to me. However, generally the new developers are of the view that they will not comply with or fulfill the obligations qua the allottees, but they keep the lenders in their hand.
So the property is unknown, then ideally you are safe.
Means say a developer is granted permission to raise the finance on development rights. On development rights, not on the land. Okay? And society says you can raise in your, we are not liable, will not be liable, will not be part of the mortgage. Now in that case, tomorrow if the developer is defaulting, then in that case what will happen? The society will go to the arbitrator or to the High Court and would ask for the termination and terminate it. And High Courts are now very much in favor of the societies. Means the developers earlier they used to, maneuver somehow aisa vaisa, but now the Samdip Mane and few other judges are very strict about it. That the societies and the members, they cannot be made to suffer for your financial discipline, indiscipline, whatever. Okay. So that is how, here the thing is that here the society is there, there are members of society. This side the allottees are there. अभी दोनों में से किसको संभाले? And law is very much clear in favor of the society. And High Court has not given these judgments just to help the society or its members. It is after very minute, detailed discussion of every part of the law. Though the Diggaj counsels were on both the sides. And thereafter, whatever has come. So it is very much settled law as of now. But I am always of the view, whenever my developer is acquiring such kind of defaulted project, then I would ensure that tomorrow it could not be shown that the new developer is taking away the benefit of whatever money or work put in by the old developer. Means undue benefit is not taken by the new developer. I don't know, High Court is not only giving judgments on law, many a times equity, many a times, there are considerations which are beyond very specific law. And if the court would find that there is something fishy and the new developer is coming in, taking away the entire benefit, जो कोई भी पैसा लगा था वो तो एनओडी का लगा था, old developer तो लगा नहीं था, and there could be even connivance between old developer and new developer. See, there are many things. I don't know what would happen tomorrow. So always when new development rights are being taken of such kind of project which are defaulted earlier, ensure that the new developer is not seen as a kind of samitra.
But tell me one thing, see, through DA, existing society member has the right to terminate and bring up a new developer. Under RERA, if you are an allottee, you can form your association, and if it's not working, you can throwing out, you can bring a new developer. Now, suppose both the situation are there in single project, then what will survive? So, जो पहले किया वो राजा है.
नहीं, if both the things are there and if the allottees can assure, if the allottees can assure that we will complete the project and comply with the obligations of the developer qua society and its members, then I don't think the High Court or the tribunals will not support allottees.
And if there is a deadlock there,
Which kind of deadlock?
so ultimately power is with the society to say yes or no.
No, the High Court will allow the allottees association to complete the development. See, old developer has defaulted, and if the allottees are ready to take up the obligation qua the society and its members, which will be practically impossible. You are asking for a situation where the allottees are taking up the responsibility to complete the project. When they say to complete the project, first obligation is to give the premises to the old owners, tenants, occupants, society, whatsoever. If that is not being taken over by someone, then nobody will help them. If you are ready to take up the responsibility and the tribunal or court finds that yes, you are genuine and you have wherewithal to do it, you can do it, then definitely they will. Courts are always in favor of protecting and balancing the things, but where they don't have the leeway, like, chalo, ho paega, then they have no other choice than follow the law.
That is possible when the substantial things are already on the structure base and
In fact, in one
very few things are to be done. That is even then that is possible. Otherwise
Yeah.
it is very difficult.
yes, 80% of the work
Yeah,
or 90% of the work is done.
Correct.
Then after there is some default.
Correct.
In fact, ये कैसे होता है पता है? There is one matter which I handled. There was this developer. This developer means a company, and same promoter of the company had another company also. In that company, he took a very big loan from Piramal, and he defaulted there. This company had become a guarantor for there. So the Piramals initiated NCLT in both. So this developer was very much knowing that this would happen. So he himself went to the society and told that this is happening. Better you take over the project. So they took over the project. The developer said, I cannot manage. Now I don't have that wherewithal, blah 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 blah. So I give up. So before the NCLT order, the rights were taken away by the society again. Now in that case, society became the assignee of the developer. Society itself became the developer in municipality. And all the allottees were given the flat by the society.
Developer will be double defaulted because in Piramal when he has when he has taken a loan, he must have given some undertaking that he will not be giving up the rights.
This was the loan was taken by some other entity. This entity was just a guarantor. This entity was just a guarantor. अरे ये तो छोटा सा बिल्डिंग था, उधर तो 200 करोड़ 400 करोड़ का लोन लिया था उधर. In this particular project कुछ नहीं होने वाला था पिरामल का. Piramal also did not take any interest in it. They also did not take any interest. In any case, before the NCLT order coming in, 80-90% of the work was completed.
If suppose a new developer will not able to fulfill some part of it, then what is the remedy for society?
Some finance.
Some part means some small, if suppose garage and all that is not done, or some work is not finished.
See, if what is approved by the BMC is not finished, you will not get the OC. But there are few things which even if it is not complete, the OC is given. And in such cases, चलो मैंने रूफटॉप गार्डन बोला था, करके दूंगा, मैं यहाँ पे गार्डन करके दूंगा, क्लिफ पे एरिया करके दूंगा, या फिर I'll give so and so alarm system somewhere. See, these are the things, amenities and all that stuff. If they have not done so, then the society as such, who is not the purchaser society but old society, will only have a right to go to either arbitration or to the court as may be provided in the development agreement and PTPA. They don't have any right in RERA. Practically, according to me, they should have, but practically today it is not so implemented.
Sir, if a landlord of the building is keep the right of the terrace, keep the right of the terrace full, not allowing.
Top terrace rights cannot be taken. It must be with the society.
Okay.
And even adjoining to the top floor, if it is not approved as a terrace, but only open to sky area, cannot be sold.
Or cannot be make it this thing like a loose.
That is a common area. That is a common area, and
You can close
only
the-
society will have right.
You can close that terrace. You can close that terrace.
Then that is a blatant breach of MRTP, municipal rules. वहाँ पे रहना को तो बाजू में रखो. You are in breach of municipal regulations.
They are allowing.
हाँ?
ऊपर वो साइड लगाने को municipal is allowing. Now,
If the municipality is allowing officially, when you are saying allowing, what I mean is officially, if it is giving the permission, then there should be some reason. There should be something reasonable. Then only it is. Then you, how can you object to it? There could be monsoon shade. There could be some weather shade. There could be some reason. And if so, there is some valid reason, then definitely you are allowed.
valid reason can be created.
I am not saying created. There has to be valid reason. That is what I